Welcome everyone to our future term strategic planning for LGBTQ people and families. Some of you I know and some of you I haven't met yet, so I'm hope to meet you soon, and I'm glad to see you here. My name is Jordan Caress-Wheelwright. I'm the Assistant Director of Planned and Individual Giving at GLAAD. I want to give you a quick overview of what our organization does, because I know that some of you this is one of the first GLAAD events that you've attended. So through strategic litigation, public policy, advocacy, and education, GLBTQ Legal Advocates and Defenders, or GLAAD with 1A, works in New England and nationally to create a just society free of discrimination based on gender identity and expression, HIV status, and sexual orientation. GLAAD was founded in 1978 and has been a leader in this movement for LGBTQ rights ever since. If you are interested in following GLAAD on social media, you can find us at Instagram and Threads at GLAAD Law, and then we're on Facebook and LinkedIn as well, other good places to follow us. So I was hired in January as the first person in this role that has a planned giving focus, and that was born out of the moment that we're in, which is a time when we're facing unprecedented threats to the gains that we've made and our rights, and recognizing that there's a huge opportunity to make an impact for the long term and for the future through planned giving. This work is personal for me as a queer person and also as a parent raising 2 young kids with my wife during this time. And I think about the future a lot. So I'm so grateful to all of you for supporting GLAAD and being here today and allowing us to continue leading the fight to protect, defend, and advance our rights. Today's panel is hosted by GLAAD's Legacy Society, an incredible group of supporters who have included GLAAD in their estate planning. I see several members here, so thank you all for being here, and we'll give you a chance a little later to say hi and give your why about why you've done that. We are so grateful for your deep commitment to this incredibly important work, and you can learn more about Legacy Society at the link my colleague is about to put in the chat. We designed this panel so that people of all ages and life stages would be able to take away some really useful information. So I hope that you enjoy the program. And without further ado, I'd like to introduce our moderator, who's Annika Bacchius-Suin. Annika currently practices estate planning and probate administration at her firm, ABS Law, LLC in Waltham. Annika joined the board of directors in 2021 and is the chair of GLAAD's Development Committee. She was named a Massachusetts super lawyer and rising star in estate planning and probate for 2019 through 2023. So welcome, Annika, and she's going to get things kicked off for us.
Yep. So I'm going to start by introducing Scott, but first, for both of our lawyers on the panel today, I want to give a quick disclaimer, which I know you guys are coming in from all over the country, which is amazing. Our lawyers are licensed here in Massachusetts. They'll be talking generally and giving information, but obviously consult an attorney in your jurisdiction if you are looking for more specific advice. We're going to start off with Scott Squillace, who is a business, tax, and estate planning attorney at Squillace and Associates. He focuses on the same-sex community and helping us with our unique planning needs. He authored a book called Whether to Wed, a legal and tax guide for gay and lesbian couples, which I love because I think marriage should be a well thought out decision as well as a romantic one. So Scott, please take it away.
Thank you, Annika. And is there a way to share screen for me to show the presentation?
Yeah, we're going to give you the privileges.
Terrific. So I will open this up and just have a few slides to go through here. Can everyone see this okay? Is it visible?
Yes, we can see it.
Great. So I was asked to talk about estate planning, which I will do briefly. And in the 10 minutes allotted to me, I could spend 10 hours, and I won't do that, I promise, in respect of the other presenters who are going to be much more insightful than me, hopefully. But at its core, estate planning, I define, and others do, that it's sort of three things: ensuring that you control your property and financial affairs while you're alive and well, planning for some responsible loved ones to make financial and medical decisions for you if you're alive but not well. Think diminished capacity / in the coma or any other cognitive decline type stuff that can happen in life. And then finally, ensuring that your property, both real and personal, goes to whom you want, when you want, and how you want after you're gone. So whenever people think about estate planning, they typically think about doing a will. In fact, I think this whole session was prompted by the Make a Will month that happens this month. And I have a little bit of a cynical view that lawyers for generations have inculcated in the popular psyche the notion that everyone needs a will because every lawyer loves a probate. But it's important to keep in mind that both a will or a trust have the same effect of making sure everything gets where it's supposed to go after you're gone. One of them only operates through the court supervised process of probate, which takes time and costs money, parentheses, when you're grieving, because that's the only time you go to use this stuff. And a trust, if it's done properly, can be settled without having to wait for a court to go through that process. So there are a whole bunch of other reasons people think about trusts, sometimes having to do with tax planning and asset protection planning. But at the core, that's the basic decision everyone has to make when thinking about doing estate planning. And then when you do this work, we always advise people to do all the other stuff that everyone needs someday in any event, like a financial power of attorney, healthcare proxy, HIPAA release, and living wills. And I say, and not just me, but others say, it's even more important now than ever, given the hostility that's occurring to our community in a variety of places, in the courts mostly, and in hostile states. But ensuring that you have some legal protections documented is a way to ensure you have the protections. The last thing I want to point out is there's a little bit of an urban myth out there that because you have a power of attorney for someone, you can make their funeral arrangements. And that's not true. A power of attorney ceases to be effective at death. And the only way anyone can have authority over your remains for purposes of making final arrangements is to have a separate type of special power of attorney that's called a designation of agent for remains. This is particularly important when people are in unmarried relationships and maybe not close to their biological family, because the default under the law for people making final arrangements is that your next of kin, defined as legal relationships, have authority. And so it's just something to kind of put on the radar screen. Annika, you want us to take questions at the end, or should I keep going and see if there's questions yet? I'll keep going.
Yeah, we're going to take a couple at the end of your presentation.
Okay, good. So I just wanted to spend a couple minutes busting some myths. My favorite one is when clients come in and say, I'm not planning to die. And what I tell everyone is a couple things. One, so far as I can tell, we have a 100% mortality rate. And life is sort of like a bell curve. Most people are in the middle of that bell curve in terms of natural life expectancy, and that's typically what happens. But every once in a while, the bus drives by or the plane falls out of the sky. And so you can never know for sure when you might pass away. And so thinking about this at any stage in life is always important. The other thing we hear often in Massachusetts, having been a leader, hard to believe it's over 20 years now that we've had lawful marriages. Thank you, GLAD, very much. And by the way, thank GLAD for doing this whole thing. I appreciate it. There are many, many rights and privileges at a state and federal level that kick in when you're married. And people have gotten a little lulled into the false sense of security that the type of planning we used to do as unmarried couples is not quite as compelling now that we have all these rights as a married couple. That is, assumes you're in a relationship in which you are lawfully married. Well, guess what? It's no surprise to anyone that in the Dobbs decision, Justice Thomas wrote that he thought, marriage for the same reasons Dobbs should be undone, should also consider being undone. and there's at least a cloud over the constitutional right to get married that we all achieved some time ago through the famous Obergefell decision that was at the time a landmark decision. But it's a little bit of a belt and suspenders. So yes, you have rights and privileges as a married couple, so long as those marriages stay available to us. And it's anyone's best guess how elections and Supreme Court decisions can unfold. If anyone had told me a decade ago we would be debating women's reproductive health still, I would have said, I don't think so. It's settled law. And of course, we've had marriage for less time than Roe v. Wade. So the point is, marriage may or may not be the end and beginning of the analysis. My other favorite one is we're common law married. So there are many couples who've been together for decades, and as I like to say, have long since figured out who's taking out the trash and who's paying for what, and feel like they don't need to get married because their rights should be recognized because they've held themselves out as a married couple. Well, it's a pure urban myth. The reality is that common law marriage existed pretty much west of the Mississippi back in the 1800s when there weren't enough justices of the peace to marry people. And there are some legacy states that still honor that concept. Most states do not. And so even if you think you're common law married, you're probably not, and therefore don't have rights and privileges. My other favorite one is I can download the form from the internet and all set, and you can. And I always tell people it might work. You'll never know, because the only time you go to use this stuff is after someone's gone. And unfortunately, in my practice, I see time and again people doing this and having mistakes in them that we have to then go to court for modifications that slows everything down and costs even more money. So downloaded wills, maybe. Putting people's names on deeds and names on bank accounts. Some people do this as a workaround for estate planning, and again, it might work, but make sure that no one ever goes through a divorce that you put, like if you put the house in your kid's name, for example, because they're going to get it anyway, and your kid happens to go through a divorce, half of your house may be subject to that divorce settlement unwittingly. Similarly, if you put other people's name on your bank account as a joint bank account holder, they still can be accessed by their creditors if there were some crazy lawsuits. My last favorite myth is I can just leave everything to my spouse or partner. They know what I want. And that may work too, as long as everyone cooperates and dies in order. But if you ever happen to be in the same car or plane, it may not work. So if you want to make sure that things happen the way you want them to happen, then doing the documentation makes the most sense. And I guess the last thing, I don't have it on here, is this notion of cascading beneficiaries. But when people name a spouse or partner and that person just doesn't live that long because they were in the same car, instead of it winding up in their estate, you can have it go to other beneficiaries of yours through a trust. So real quickly, a couple more slides. What about taxes? Everyone knows a lot about income taxes because every April 15th or October 15th, if you're on extension, you have to do something. But people often forget about estate taxes that kick in both at the state level and federal level. Not every state has estate taxes. There are places that have zero estate taxes at a state level, like Florida and New Hampshire and Texas and different places. But Massachusetts is one that does when the estate exceeds $2 million. And people often forget what's included. It's everything that you had control over during your lifetime. So it's not only your bank accounts and your retirement accounts and the equity in your home, but it can include the proceeds of life insurance policies. Life insurance is one of the most misunderstood asset classes in our world because people think of it as not taxable because the proceeds of life insurance are not income taxable to the beneficiaries, but the value of those proceeds are all includable in the decedent's gross estate for calculating whether or not you owe an estate tax. You don't owe it, your estate does. It's due within 9 months of date of death in cash. They don't care whether the property has been sold or not. So it's just something to pay attention to and think about. Last and perhaps most importantly, philanthropic planning. So I always like to remind clients, death is the biggest liquidity event you'll ever have. Everyone doesn't, most people do not think about their estate as large as it actually is, because it's usually not all cash in your checking account. You have equity in your home, you have retirement account assets, perhaps, maybe other business interests that are illiquid. All of those things are valued at death and eventually sold and become part of your estate. So I guess the first point to think about is you may have more in your estate than you think you have if you want to do some piece of charitable or philanthropic planning. The other thing I often hear is, we may have more, but we don't have enough. And I really always want to make sure my spouse and or partner and or children are provided for. And so I always like to suggest that people can think in terms of a formula clause that says something like this: if there's at least X left over after all the dust settles, then I'm okay with Y percentage above X going to my favorite charities. So if, for example, the numbers on the page aren't what you thought they were going to be, then you want to make sure your loved ones are provided for. But if for whatever reason there's more, then there's a way to start providing for charities. Another technique I like to suggest people think about, I call it the kick the can strategy. If they're not sure what charities, other than, of course, GLAAD, they want to leave to, they can say, well, leave the X percent to whatever charities I'd most recently been giving to in the last 3 or 5 years of my lifetime, as evidenced by my income tax return. And that way you keep a rolling list and you don't have to remember to keep updating things. Another little technique for philanthropic planning is, even if you don't have anything that you feel as though you're able to leave to your favorite charity, in order to make sure it never reverts to the state, we always have to have this disaster clause called the remote contingent beneficiaries, so that everyone you named, if all of them are gone, it goes somewhere. And here's where people sometimes pick their favorite charity. And even if it doesn't kick in because you are survived by loved ones, if people want to know what you would have wanted to contribute to in their memory or their honor, that gives everyone a really clear roadmap of what your favorite charities are. There are all sorts of other techniques out there that are beyond the scope of this presentation, like charitable trusts and annuities and so forth. But I guess the last point I want to leave everyone with is, there's a really easy way for everyone to get started with this. Just pick some modest percent, 3, 5, 10% of your retirement account to go to your favorite charity. And already then you've started to do some philanthropic planning. So I'll stop with that in respect of other people's time and take questions whenever you want.
Thanks, Scott. I really appreciate it. We're going to do a bigger Q&A at the end, but for now, I think my number one question that I get a lot is like, what if I don't have these documents? What happens?
Oh, thanks, Annika. I forgot to mention that, but there is a provision in every state's law. It's called intestacy, and it's a roadmap for who gets what if you never did a will or a trust or any of this stuff. And it's generally your next closest relatives, but there are really quirky rules in every state. So if, for example, you're married in Massachusetts with no children, your spouse doesn't get everything. There's a formula where your spouse gets a certain amount, and then it gets split between your spouse and your parents if your parents survive you, or your siblings if they survive you. So, and what's even weirder is, if they're not around, then we start looking for cousins and aunts and uncles and other blood relations who may or may not be people that you really wanted to benefit from your estate. So the law does have a plan for everyone, and it's essentially next of kin in order of consanguinity closeness, but it may not be what you want, because we always have the difference between our biological families and our logical families.
I like that. Then my one last question, because we don't have anything in the chat yet, but we'll keep going, and maybe at the end we'll have more in the chat. Well, I do just get one.
Oh, there's one.
Yeah. Can you deliberately exclude people from the will, Scott?
Yeah, absolutely. And it's done all the time. So for many years, there was an old case a long time ago that where someone was not mentioned in a will and they were otherwise a natural heir. And the case said, well, they were forgotten about, so we're going to include them as if they were forgotten about. And after that case came out, lawyers started drafting wills to say, for the people they wanted to exclude, well, I give this person $1 or $5 or $10 just to prove they weren't forgotten about. Well, then we learned over the years that when you give them even a penny, they're entitled to all the notices and all the accountings and can just slow things down and make everyone's life miserable. So in order to make sure they're not forgotten about, you just simply mention, I have these relatives that I have intentionally not provided for and are to receive nothing in this will. I had a couple recently where it was a gay couple who were elderly and had been estranged from their biological families their entire lives, and their families were hostile to them, including end-of-life illnesses. They weren't around for anything. And then they showed up, afterwards wanting, can we at least get the family photos? And they had said in their will, you get nothing, so nothing meant nothing.
Mm-hmm. Yeah, that's a great point. And then my final question is estate planning a one and done kind of thing? Like once I do it, I never have to look at it again?
Yeah. So again, I'm biased because this is what I do for a living. But in the same way that your retirement plan, you would never go to a financial advisor, and we're about to hear from a good one in a minute, and say, here's what I make, and here's where I want to live, and here's when I think I'm going to retire, and what I might spend, and let them set up a retirement plan for you, and then not talk to them for 40 years and come knocking on their door 40 years later saying, okay, where do I get my check? Because life changes, right? Taxes change, your assets change, your family situation changes, your wishes may change. And so dialing the knobs on this stuff always makes sense. We recommend people look at it annually. Some people don't think that's too frequently. I always say, as soon as you tell me 3 things, I'll tell you how frequently you need to look at it. Tell me what day you're going to die, tell me what your asset values are going to be on that day, and tell me what the tax laws are going to be. So it's important, just like retirement and financial planning, these are the same assets you're planning for to look at from time to time and make sure it stays updated.
Yep. I also do this for a living, so that's why I was gonna throw that one to you, a little softball pitch. All right, well, thank you so much, Scott. We're gonna have more questions at the end, but for now, we're gonna move on to attorney Lisa Wilson. Lisa is one of the founding partners of Wilson, Marino, and Bonnevie, a family law, LGBTQ family planning, and real estate firm in Newton. She's going to talk to us about the family side of things, the marriage, divorce, kids, prenup, and all that. All of that fits together with your estate plan. So take it away, Lisa.
Hi, good afternoon. Thank you, Annika, and thank you, Glad. So as a family law attorney, I represent individuals who are either coming together to form some type of a committed relationship like a marriage, or representing individuals who are trying to untangle their relationship like a divorce. For those entering into a marriage, the best way to protect assets, whether they're premarital assets or postmarital assets, and the ability to control philanthropic pursuits or giving with those assets is through a prenuptial agreement. Or oftentimes you'll hear the term premarital agreement. So what is a prenuptial agreement? Well, it's a written agreement between 2 people intending to marry, who actually do marry, that defines each party's rights to the other's premarital property, postmarital property, and potentially gifted or inherited property, and any other property the parties may acquire, either before or after during the marriage. So, and property is a very broad concept. We're not talking just about real estate. We're talking about property of any form. Whether it's tangible or intangible, real estate, personal. I mean, it really is quite a broad definition. And in addition, a prenuptial agreement can define a surviving spouse's rights to the estate of the other spouse upon death, giving one the ability to distribute or gift his or her estate any way he or she deems appropriate, as that may change from time to time. So it's really about control. Now, this is particularly relevant for individuals who may be entering a second marriage with children and they want to, prefer their children in an estate situation, or for those who wish to make philanthropy a main component of their estate plan. So why is that important? Well, upon divorce and without a prenup, the state statutes will define what makes up the marital estate, and a judge's application of that statute and the case law interpreting that statute will determine how the marital estate is divided, unless the parties can reach some other separate agreement. So this is particularly important in a state like Massachusetts, where the definition of the marital estate is so broadly defined that it includes any interest a party may have, no matter when it was acquired or how it was acquired. And that's different than some other states. As actually as you move west, we see a more narrowing of the definition of property. But at least here in Massachusetts, it's premarital assets, assets acquired during the marriage, even assets acquired during the separation while you're going through the divorce process. It is all in the marital bucket, so to speak, and subject to the division based on the discretion of the judge. Now, what about death? So I had mentioned that a prenuptial agreement may address the issue of death. So in certain state statutes provide that a surviving spouse is entitled to a portion of the deceased spouse's estate. And there's other laws that say you can't disinherit a spouse. However, through a prenuptial agreement, the parties are free to waive whatever rights or claims they have against their surviving spouse's estate, enabling the estate plan of the deceased to control the disposition of his or her assets, including those philanthropic bequests that may be a priority in the estate plan. Now, to be clear, not every agreement made prior to a marriage is a prenuptial agreement. Many times prior to entering into a marriage, the parties will, jointly purchase real estate. In some respects, sometimes that's the first step in a committed relationship, the acquisition of real estate versus the actual marriage. And I will have many clients that come to me and say, well, we had this ownership agreement concerning the real estate. Well, that's not a prenuptial agreement. It doesn't comply with the laws and requirements of what's needed in order to satisfy the terms of a prenuptial agreement. But typically an ownership agreement can be incorporated into a prenuptial agreement so that it continues to give life to it. But it is not what's called a prenuptial agreement. And of course, clients always indicate that there were certain verbal agreements as to whether someone would have the ability to make a claim against either a premarital asset or family business or a trust interest. But again, verbal agreements aren't binding, and they certainly don't constitute a prenuptial agreement. Now, every state has its own set of rules that must be followed in order for a prenuptial agreement to be valid and binding. And they typically are quite strict. For example, in Massachusetts, there needs to be full financial disclosure. Each party needs to be represented by counsel so that they've gotten advice of counsel as to the full effect of the agreement. The agreement must be fair and reasonable at the time the parties enter into it. And the court also takes a second look. So during that divorce process, should that marriage not make it, and now one party's looking to implement the terms of the prenup, the court's going to take a look to see whether, did anything happen during the marriage that makes the enforcement of this agreement unfair or unreasonable. So there's a fair amount of protection, but for the most part, the court assumes that people are competent to contract and enter into these types of agreement. And it is a way to control your assets and control your philanthropic pursuits during your marriage and then following a divorce. So what about a divorce? What if you don't have a prenuptial agreement and you're in the midst of a divorce? Now, obviously, this is far more problematic. And you're subject to a judge applying an innumerable number of factors, some of which are mandatory, some of which are discretionary, and in connection with the division of the marital estate. But oftentimes we find that, we can get kind of close to an agreement. Maybe we're $50,000 apart or $100,000 apart, but we're close. The parties are really close and they're just stuck. And that the fact that they're stuck is usually reflective of a variety of issues, many of which are emotional. And so one common tool that I use is to see if I can get the parties to align on a philanthropic donation. Maybe they can agree that a certain amount of money should be donated to GLAAD as a way of resolving their dispute that addresses the fact that maybe one didn't want the other to get something, but it gives them a tax donation. It makes them feel good and it helps them resolve the case. So from that perspective, using philanthropy as a way to resolve disputes is really sort of an unsung tool in the toolbox that I recommend that, if you find yourself in that position, it's a good way to bridge the dispute. So, any questions?
I have a question. What if you got married and you were young and you were in love, and also you maybe didn't think to stop and get a prenup before you went forward with it? Are you kind of out of luck now? Or if you and your spouse are on the same page, is there something you can do to do it now?
Well, there's certainly something that's called a post-nuptial agreement. But similarly, it requires that the parties have this full disclosure. And the reason for the prenup, usually the consideration is that the marriage would otherwise not be sustainable if this postnuptial agreement weren't put in effect. And sometimes that's true and sometimes that's not. But again, and again, that's a similar type of agreement that's subject to court oversight. But in terms of the level of scrutiny, the court scrutiny on a postnuptial agreement is going to be much higher than a prenuptial agreement. And certainly the most scrutinized agreement would ultimately be the divorce agreement. So it's certainly worth a shot, particularly if the marriage is on the rocks, and it really is going to be a way to solve or enable the marriage to move forward. But yeah, so there is an option there.
Yep. And then I think one thing that there's obviously going to be people on this call who are of the marrying age and are thinking of that. But what about when it's time for your young adult kids to get married and all of a sudden you're a little worried about what that means for your estate plan? So if your kids are also young and in love and make bad decisions, what does that mean for your estate plan? What are the effects of a divorce of one of your kids when it comes to your estate?
Well, yeah, I mean, this is where the rubber hits the road. Unfortunately, they're not traveling along the same lane. You really have to pick and choose a lane, meaning you may want to support the couple, support your child, and gift and put assets in their name in an effort to reduce your estate tax and the value of your estate. But it really is creating marital assets on the back end for that young couple, and that may not be appropriate. And there's an awful lot of litigation, not only about the actual assets that have been transferred from parent to child, but parents have set up trusts, some of which are irrevocable, that name a child as a beneficiary, and that irrevocable interest in the trust can be considered a marital asset. So it's a very challenging matter for parents who are of high net worth that wish to make certain gifts to their children. I mean, my recommendation is to keep the money, and you can give as needed, but you don't need to commit.
My recommendation is you give it to GLAD.
Hopefully the marriage will, if the young kids are gonna make, they can give other amounts of money over time, but there's no need to rush it.
We have another question here about, is there going to be a need for a prenup if there's no kids, same-sex couple, everybody's got about basically the same assets, no real family left? Is that still kind of a situation you see a prenup? I mean, I think you should always have a prenup. I think there's nothing better than getting legally married, but with a prenup. I think that's the best of all worlds. But the question here is, you know, if there's no kids, everyone's got roughly the same amount of stuff, no parents, family they need to take care of. Is that a kind of still a prenup situation?
Well, it could be, and certainly there's always the issue of spousal support, even if there's not considerable assets to address. But do you want to address the issue of spousal support, or do you want the court to do it? I mean, that really is the thinking behind a prenuptial agreement generally. Who do you want to have make the decision? Do you and your intended want to be able to control what happens to your state, whether it's upon death or divorce, or do you want the court to make that decision? So, I think I agree that you can always amend your prenup, you can always revoke your prenup, but I think it's wise to have one going into a marriage.
I always tell clients you can always be more generous with each other when you split up, but let's make a decision now when you still really like each other.
Exactly.
So, all right, we're going to take any other questions at the end, and now we're going to move on to our financial planner. Lisa, thank you so much for your expertise here. Our financial planner today is Alix Magner. Alix is a first vice president and financial advisor at Morgan Stanley. Alix is based in Minneapolis and San Francisco, so not Massachusetts like the rest of us over here. But the nice thing about financial planning is you don't have to take the bar every time you go to another state, so they can be a little more broad in who they serve. So Alix, we've heard about the legal side of things, which mixes in very much with your financial, but as a financial advisor, what advice do you have up for us today?
Great, thanks. And hello, everyone. So as Annika said, I work with people all over the country. I work with my brother, Charles, and my brother and I are both part of the LGBTQ community. I also have a kid who is trans, and I work with a lot of clients that are part of our community. So not only does the work that GLAD does really important to me, it's also something I love to talk about. So I'm going to share 3 things to think about in terms of giving from a financial planning perspective. 1, the first question that I think makes sense to think about is, what's the money for, right? What is your money actually for at the end of the day, right? So start with why. What's important about money to you? And one way to think about this is to ponder and write down your answer to this question, which I really love. So imagine that you are financially secure, that you have enough money to take care of your needs now and in the future for you and your family. The question is, how would you live your life? What would you do with your money? What impact would you want to make? What world would you want to be a part of? Don't hold back. Describe a life that is completely and richly yours, right? That is your why, right? That is what should guide your giving when you think about how and where to give. The second piece is then, how much do you give? For most people, they first need to answer, do I have enough accumulated, right? But what's enough? For some people, $1 million is more than they will ever need. And for some people, 6 million isn't nearly enough, right? But no matter how much money you have, we can all fall into the scarcity mindset where we worry that if we give now, we're going to run out. So how do you address that? Do a financial plan. Not just the free plan from the guy at the bank or that calculator online, but a real financial plan, ideally done by a CFP, a certified financial planning professional, where you can look at the numbers, at your numbers, and understand how much capacity you have to give now and after you're gone without risking your ability to provide for yourself and for your family, and update that plan annually. I have a client who says, Alix, tell me how much I can spend and give now without having to eat dog food when I'm 80, right? That's what a real financial plan can tell you. How much can you give and spend and still pay for the nice old folks home and not have to eat dog food? If you're in your 30s or 40s in that realm, you might not even be thinking that far ahead yet to the old folks home, right? It's more just, can I retire, right? Am I gonna be able to stop working? Still, having a plan helps you understand how much you can give and still achieve your goals. So I'm based in Minneapolis. After George Floyd was killed, one of my clients called me and said, Alix, I spent my emergency fund. Like, okay, what did you spend it on? What did you spend the whole thing on? She's like, I gave it away. I donated it, right? It was an emergency, right? But she said we had done the financial plan and I knew that it would be okay, right? I knew that I would be okay and I could make this impactful donation for something that really I felt like needed to happen and I would still be okay. With people in their working years, it's all about automation, right? Setting up the systems and the processes so that you're not stuck in analysis paralysis every time you get a paycheck or a bonus, you think about giving. So Scott mentioned this. I typically work with clients to set up a goal, right? He was talking about putting a percentage on your beneficiary. I think about what's the percentage of income or of assets that you can give away each year, and then break that down. So half or more is going to the organizations that are doing the most impactful work on the things that you care about the most, right? And the rest is available for the things that come up during the year. The fundraiser that you go to, the cousin that's doing the raising money for something, right? But I find it really helpful to think about and make the decision once about how much to give, right? Based on your income, your assets, your financial plan, your values, and then set it up. So even if your life and the world goes sideways, your giving is still on track. The third thing to think about is how to give. There's a lot of ways to do this. Two of my favorites are, one, a donor advised fund. This is a charitable checking account. It's a way to put money, securities, cash into an account that you can use to support charitable organizations you care about. It is great for people that have huge income years, people who are exercising stock options, selling a business, getting a big bonus, people who get a severance, right? Those big income years, because you get to take a one-time deduction. But it is also great for just regular people doing regular giving because it simplifies your charitable giving. You don't have to go find the receipts, right? For anyone who's gone through the process of gathering your receipts, searching for the email and your paper files for those confirmations of donation, it is a huge time saver to use a donor advised fund for giving. The second thing that I love to do for charitable giving, for anyone who's over the age of 70 and a half, so this may be you, this may be a tip for your parents or people around you, the most tax efficient way to give is a QCD, or qualified charitable distribution from your IRA. This has to be from an IRA. You can't give from a 401k, but it allows individuals who are 70 and a half or older to donate up to $105,000 directly from an IRA instead of taking the money as income and paying income tax on it, right? So this keeps your tax bracket lower. It lowers potential future RMDs, or required minimum distributions, right? And you don't pay income tax. Even if you're one of the people who is now going to take your RMD at 73 or 75, you can still do this QCD at 70 and a half. You can use it to support multiple charities. If you're married, you and your spouse can each contribute $105,000 from your own IRAs. But no, you cannot do a QCD into a donor advised fund. I get asked that a lot. I hope that was helpful. I'm going to pause there and I'm happy to dig into any other part of it.
Thanks, Alex. That was really helpful. I'm gonna start with a question that's gonna be both for you, and I think maybe Scott and Lisa are gonna want to chime in here too. How can charitable giving, which we're all here, we're all interested in it. Hopefully we're all specifically interested in giving to GLAAD, but how can that impact your state and federal estate tax obligations? You just talked a little bit about income, Alex, but like from a estate tax standpoint, how does that work?
That's a great question. This is probably more of a Scott question, but for clients that I know are going to, they are going to pay estate tax at either the federal or the state level, right? We are looking at, okay, let's make sure that you are adding a charitable beneficiary on life insurance, 401k, IRA, trusts, right? And even though the federal estate tax limits are pretty high right now, right? They may not always be, right? Again, this is back to the, let's look at it every year. But a financial plan can tell you, are we projecting that your assets are going to be a lot higher in the future, right? And so we want to really be planning for that giving now so you're giving those funds away and not just paying tax on those assets.
And Scott, if we can have you weigh in, at least from federally and here in the beautiful Commonwealth of Massachusetts.
Yeah, just to build off of what Alex said, it's a deduction on the estate. So if your estate were to be subject to either a state or federal estate tax, anything you give to charity reduces the value of what gets taxed. And you get a double benefit if the reduction is coming from qualified plan assets like retirement accounts, because you're avoiding both the income tax eventually that would come out when those assets are paid out, and you're reducing your estate tax. Alex mentioned, we don't know. We know a little bit about the levels now. It's a crazy high number of 10 million per person index for inflation, currently 13.9 at the federal level, scheduled to sunset at the end of 2025. So I remind all of our wealthy clients, make sure you hurry up and die before the end of next year, because it goes back to the Obama era level of 5 million per person. Also indexed for inflation will be around 7. The only in related taxes, and it's the other side of the same coin of something Lisa mentioned in terms of, parents sometimes think of giving away assets during lifetime to reduce the size of their taxable estate and may make it vulnerable to going sideways if their kids go through a divorce. And yes, there's been a lot of litigation on this, and yes, it's tricky, but there are ways to do it to protect it, I think, from divorces. You just have to jump through some hoops to make that happen.
And hope that the SJC doesn't change their mind again before you die.
There's that.
The other question I think is mostly a Scott question as well. If you have to update a trust, you have to redo the whole thing. Is a will better if you have to change it regularly, or are we looking at a trust? What do you think is the best if it's someone who's going to be making changes on a regular basis?
Either of them costs something to change. In a will, you can amend it by something called a codicil. In a trust, you can amend it by something called an amendment. Some lawyers, depending on the scope of the amendments, prefer to do a restatement, sort of a new and improved version. It's almost always easier to go back to whomever you worked with to start with to make changes, because most lawyers don't change other lawyers' documents because there's sort of malpractice issues. So if you're needing to make a change and you want to go to another lawyer, they're going to probably want to start all over again in any event. But I don't think one or the other is easier or harder to make changes from. I, as I mentioned earlier, think one is easier to administer post-mortem. That's a fully funded trust, and a will goes through probate that takes time and costs money.
And I guess a good distinction, and I think you and I will probably have just off the top of our heads, but for our audiences, we're talking about revocable or living trusts, which you can amend as many times as you like. Really no difference there. If you are talking about an irrevocable trust, which is a much more complicated tax and other things, then you don't have as much flexibility for amendments and things like that, but there's some.
Precisely right.
So to Nan, who asked that question, it really depends on what type we're looking at of trust. But generally speaking, of what we've been talking a lot about with living trusts and wills, you can update either of them pretty regularly. What I like about a trust is that it's private, and a will eventually be public record. You can go see JFK's will in Barnstable County Probate if you're interested. Any other questions before I turn it back over to Jordan and the GLAD team? Raise your hand, throw them in the chat. Well, thanks to our panelists. You guys have been fantastic. I could talk about this all day. That's why they made me the moderator, and why the questions went on so long. So I'm going to turn it back over to Jordan to take us to the end.
Yeah, thank you. Thank you so much to everybody. Those presentations were so helpful, and hopefully everybody was able to is going to be able to walk away with something that's useful to them. I wanted to give a huge shout out to our Legacy Society members who are here today. I know there are several of you. I have already seen the tremendous impact of planned giving here at GLAD. Last year, we received a large bequest from a longtime supporter, and with a deep commitment to justice for LGBTQ people. And this bequest helped to fund the largest expansion of our legal team that we've ever had here at GLAD. And so this growth will allow us to step in where we're needed and expand our impact far beyond New England. So that's to say that this kind of giving can be really transformational for organizations like ours. So we appreciate anyone, all gifts, but planned gifts do have the potential to really make a huge impact in the future. So I know that, I know that Rick would like to say a few words, and if anybody else from Legacy Society would like to kind of talk about why they've chosen to include GLAD in their estate plans, feel free to do that now. And I know that, Carol, if you can put the information for our panelists in the chat too, and for me, in case you have any questions for me, just for following up. But Rick, if you'd like to say a few words.
Sure. Thanks. Can you hear me? Am I okay? Hello, everybody. First of all, I'm so thrilled to see that this topic has taken on, it's gotten legs, if you will. I know when I was in a leadership role at GLAD in 08 through 13 as president of the board. I know, Scott, we've worked together. You've come and helped educate the board and all of that. And it's just really good to see all of this working out. I just wanted to, from a practical point of view, I just retired a couple of years ago. And of course, every time I go on a flight, I'm like, oh my God, I don't have this all taken care of. And it would just drive me crazy. And finally, all of that's in place. And very simple. It's just a simple way to do it. I looked at everybody that I was going to give money to when I leave this earth. And I looked at organizations. I have three and I just did it as percentages of the assets that are left. And it's very nice because things change. Some people pass on too, and they can't be in it as well. And there's all sorts of ways in which around that. But I know you have the experts on the line for that. I'm just doing this from a sort of a crazed, God, I got to get this done person and trying to figure it out. And that's what I did as I worked with my investment manager and looked at all my assets and just said, I think there's 5 funds and they had to do the same for each. So there were like maybe 12 entities, and I just did it as a percent. So as I called the organizations, I said, well, if I die tomorrow, you'll get $100,000. If I die when I'm 90, you'll get $1. But whatever, it's done. So I'm just done with it. But you know what? It was said once, if you don't do anything about it, you've willed everything to the government, basically, and you didn't really want to do that. So that's why I implore people to just sort of do something. And it's really nice to know that you've left something for everybody else to enjoy, to get the work done and the mission that you love and share with everybody, to just sort of give them what they need. So that's all I wanted to say. So I'm very pleased to see this grow and have legs, and I'm glad to hear about the recent bequest. So great, good job.
Thank you so much, Rick. Oh, and one thing I forgot to mention is that Scott is a member of Legacy Society and part of our Equal Justice Council, and Lisa's part of Equal Justice Council as well. So we really appreciate your support in joining us for this panel, and also your support of GLAD, above and beyond support. So thank you. And Alix, it was so great to have you here today. And hopefully y'all reach out to these folks when you need some support while you're working on your financial and estate planning.
And Jordan, I do want to say, you don't have to. Your estate plan is private to you until you pass away, and if you have a trust, it's private even longer. But GLAAD wants to know if you leave them something in any of your documents, even if it's remote contingencies, because then you get to be a legacy society, and that's the cool kids crowd. Many of them are here on this call right now, so let us know. You don't have to, but it is really nice to know. It really helps for planning, and also so that we can celebrate you while you're here.
Yeah, and we're gonna reinstitute a Legacy Society brunch this year in April, where I'll be able to hopefully see some of you there. And there's special invitations to different events. And also it's just really helpful for our planning purposes to know if there's money coming down the road, because that allows us to do things that we couldn't otherwise do. So
I'm gonna go update my documents so that I get that invitation.
So yeah, reach out to me, and we're going to be sending out this recording. We're going to be sending out the information of everybody who's on the panel and ways that you can learn more about making a planned gift to GLAAD as well. But we're so grateful for all of you being here, and we will see you at the next GLAAD event. Everybody have a great day.